we show up at various city council meetings is we see these tenant rights groups. A lot of them are sponsored by different socialist organizations or tenant unions or tenant rights advocacy groups. And what they're doing is they're literally going across the United States and taking different metropolitan areas and categorizing them as A, B, C, or D. And right now they're working off the A list to try to implement rent control in major cities across the United States. And then they'll eventually keep working their way down the list. And when we're in there at a city council meeting fighting against some of these rent regulations, invariably these tenant rights groups don't even live in these jurisdictions. And they're coming from outside and rallying the renters in these cities to push for these types of regulations. You can go to the next slide. And what we've seen more recently is we've seen various eviction moratoriums popping up, both starting with the governor's executive order authorizing eviction moratoriums to be put forth in local jurisdictions. And now the state has its own eviction moratorium. And in fact, the governor just this week extended the statewide eviction moratorium until September 30th, 2020. And it's possible that he could even extend it beyond that. And of course, we have the various counties with their own local eviction moratoriums, and then dozens and dozens of cities throughout Southern California and actually throughout all of California that have various eviction moratoriums. You can go to the next slide. And if you're not familiar with eviction moratoriums, these are some of the common provisions we see. First of all, they protect renters from being eviction if they've been adversely impacted due to COVID-19. And what adverse impact due to COVID-19 means, it means job loss or a substantial reduction in work hours, increased medical costs because either they or a family member has come down with the coronavirus, or they have to care for a family member, or even have a child that's been put out of school because of all the lockdowns. And these provisions typically also prohibit no-fault eviction. So owners that may have a rental property and want to move in a family member are unable to do so while one of these eviction moratoriums are in place. And as you saw, there's a long list of local jurisdictions that have implemented these eviction moratoriums. And basically, for the most part, all of them have a slightly different twist to them. So if you own or you have clients that own properties in different local jurisdictions, whether it be unincorporated areas of LA County or the city of Santa Monica or Arcadia, you really have to look up those specific eviction moratoriums to really understand what your rights are as a property owner. These eviction moratoriums typically, because you cannot evict these renters and these renters are unable to pay rent, they usually provide for some kind of repayment period. And what we've seen is some are 3 months, some cities are 6 months, some are 12 months. We've seen the 3 months be extended to 6 months and 6 months being extended to 12 months. And it's possible that some of the 12 months may be extended to 15 or 18 months. We just don't know. All this stuff is very fluid. These eviction moratoriums, some of them had specific expiration dates and they keep on getting extended and extended and extended as we continue dealing with this COVID-19 pandemic. In some cities like the city of LA, the repayment period today is 12 months and there's no specific payment amounts that need to be made over those 12 months. And it's not like a renter is required to make pro rata equal payments over the 12-month period to repay back rent. A renter literally has the right to repay the rent in one big balloon payment on the last day of the 12th month. Some cities require the renters to provide documentation to owners. In a city like Los Angeles, there is absolutely no requirement. In fact, there's really no obligation for the renter in the city of Los Angeles to let the owner know that they're not paying rent due to COVID-19. And so a lot of cases, owners are being left in the dark and not collecting rent. In some cities, there's a requirement to provide notice within 7 to 30 days after the rent is actually due. And again, you're leaving owners in the dark and unable to make changes in their expense structure, not knowing whether they're going to get rent or not. And then 3 cities actually require the owner to provide notice to tenants of their rights. And those are in LA, Pasadena, and Santa Monica. And LA.
Join the meeting.
City of LA, welcome by the way. The City of LA had a May 27th deadline to provide that notice. So if you own property in the City of LA or you have clients in the City of LA that have not provided the notice, they need to do so right away. There's actually no penalty, monetary penalty for not providing the notice, but it would be a reason to have an eviction matter dismissed if that notice is not provided. You can go to the next slide. So there's a number of proposed local ordinances and also statewide ordinances I'm going to talk to you about. I'm also going to talk to you about some recent state laws that were passed that you should be aware of if you aren't already. For the ones that are pending, a lot of this stuff is very, very fluid now and are changing constantly. In fact, since I prepared these slides, and I just sent a latest draft yesterday for today's presentation, some things have changed, or there were a couple things that I missed. But you need to know that if you own property, or one of your clients owns a property with a federally backed mortgage, typically Fannie Mae or Freddie Mac, the tenants in that building, or if the tenants in the building receive any type of federal subsidies like rent vouchers under the Section 8 program, there's a prohibition for evicting those tenants right now under federal law. The governor also has an emergency order declaration. As I mentioned, that's now been extended through September 30th. It was July 28th when I prepared this slide. There's also the governor's emergency declaration that has been in place for a while and was just extended for several counties in California through the end of 2020. And what that does is an anti-gouging provision kicks in. And in many cases, prices cannot increase by more than 10%. And that could also apply to vacant apartment units. Many of you know that under a state law called the Costa-Hawkins Rental Housing Act, which was the fight we had in 2018 with Proposition 10, there's a concept called vacancy decontrol, where when you have a vacant unit, you can rent that unit at market. So owners that may have been renting a unit and got caught under rent control way below market, when the tenant vacates, they can raise their rent to market. Well, if you're raising the rent to market is more than 10%, you could trip up this anti-price gouging rule. And so we advise that anybody who is looking to increase their rent by more than 10% for a vacant unit seek legal advice before doing so. We don't want anybody to trip up and find themselves staring down at some huge penalties that could come around. The City of Los Angeles, on top of their eviction moratorium, has an rent increase freeze, and that's in place for 12 months after the lifting of the emergency declaration. So with the governor extending that now to September 30th, 2020, there will be no rent increases in the City of Los Angeles for 12 months after. So that extends now to September 30th, 2021. LA City is looking to provide the just cause eviction rules for non-RSO units. There are just cause eviction rules already in place under Assembly Bill 1482 for non-RSO units, but the City of LA feels like those aren't strong enough, and they're looking to apply their local rules to these units that aren't covered by their rent control law. For those of you who don't know what just cause eviction rules are, and there's nothing just in them for property owners, but what that means is you can only evict a person for specific reasons stated in the law. And those are typically non-payment of rent, conducting criminal activity, destroying property, creating a nuisance, not allowing access to a unit. And there's generally anywhere from 10 to 14 different reasons that are listed in the law, and that's called just cause eviction rules. And those rules do not typically allow for evicting a renter because they're rude to you and you just don't like them. You have to have a specific reason stated under the law. LA City is also looking at right to counsel. The city would like to pay for attorneys of tenants facing eviction, and they're currently testing that out in 3 zip codes within the city. And we're watching that very closely. And then LA City had recently proposed a vacancy tax. While every property owner is now suffering with not collecting rents because of this pandemic, the city wanted to propose a new tax. They're just really great people on that city council. They were looking to put it on the ballot in 2020 and spend $12 million to market and propose the ballot initiative. They thought better of it, and they've decided to defer it because it's a much more complicated issue that they could have dealt with in a week and a half time frame that they were looking at. So we'll probably see that back in 2022. The city council apparently thinks that owners of rental property are leaving their properties vacant for some reason. Most people want to pay their mortgages and their property taxes, insurance, and want to rent their units rather than leave them vacant. But apparently the City Council of LA thinks differently. The Judicial Council, the body that creates all of the court rules in California, has added another 90 days under Emergency Rule 1 that they recently passed to the eviction moratorium. So now with the governor's eviction moratorium extending through September 30th, owners cannot get into eviction court for another 90 days after that. So that puts them out to the end of this year. And then what we think is there's going to be a huge backlog in eviction cases. So even once people can file starting at the beginning of 2021, it could take anywhere from 6 to 9 months to adjudicate those cases. So tenants are going to be living free in apartment units for a very, very long time because of these eviction moratoriums and then the Judicial Council's emergency rule. The LA County has proposed a right of first refusal to acquire properties that may be facing foreclosure. And what they want to do is they want the owners to first offer them to a nonprofit or a county agency, or even the tenants that live in their building, to keep them as residential rental properties. And then the LA County just recently proposed fees for their rent stabilization ordinance. Along with every rent control ordinance, it's always the property owners that need to pay for the administration of the regulations that govern them. So the county is charging $90 a unit for rent controlled units and $30 per unit for non-rent controlled units. And these are some of the highest fees in the area for this. And then the city of West Hollywood is proposing once again, for probably the 3rd or 4th time, a 1-year minimum lease requirement. What that means is the property owner not only needs to offer a 1-year lease to a prospective tenant, but the tenant needs to take a 1-year lease. There's no more short-term leases, no more leases for 3 or 6 months for people that maybe may have family at Cedars-Sinai that need their care, or for people in the entertainment industry that may want to live in West Hollywood. It's just going to be forbidden. You can go to the next slide. If you haven't heard, we have a couple of ballot initiatives, and we just got the numbers for these yesterday. The first one is the Rental Affordability Act. Up until yesterday, we had been calling it Prop 10 version 2.0. It's just another cut at what we fought against last November 2018 with Proposition 10. It's another attack on Costa-Hawkins, and it limits the amount you can charge for rent when you have a vacancy. And that limit is 5% per year for the first 3 years. So people that have rental properties that they're receiving rents for that are severely under market, they would never be able to catch up with this provision. It also possibly puts single family homes and condominiums under rent control if 2 or more are owned. And it also reverses Assembly Bill 1482. It would take all those properties that are under the statewide rent control with much more generous rent caps of 5% plus CPI, and could put them all under local rent control, where in cities like Santa Monica, owners get 2% or less increases per year. The city of LA typically 3%. So this could have devastating impacts on rental property and severely impact the values of rental property. Same type of rules that got passed in New York about a year and a half ago. The Wall Street Journal reported that rental properties declined in value by 30 to 40% because of that. Again, it's the Rental Affordability Act, Prop 10 2.0, and it's got its ballot number. It is going to be Prop 21. So please remember that Prop 21 is the new Prop 10, and you need to encourage everybody you know to vote against that. The next bill, a proposition of interest, is going to be the California Schools and Communities Funding Act, another false title on this one. We call it split roll. And what this would do is this would reassess commercial properties, and commercial properties meaning non-residential properties, based on current value. It would basically, commercial properties would lose their Proposition 13 protections. For those of you who are as old as me, Prop 13 passed in 1978, and it basically sets the assessed value for property tax purposes at the price you paid for the property and limits increases to no more than 2% a year. What we saw before Prop 13 got passed is homeowners, particularly elderly retired couples, would be losing their homes because they couldn't afford their property taxes anymore. The property values were increasing so rapidly in California, people had to move out of their homes because they could no longer pay for their property taxes. And this could have the same devastating effects on businesses. You know, imagine the local car wash that's owned their property for 40 years. Suddenly their property taxes could, you know, quadruple or go up sixfold, and they're going to have to pass those prices on to us, the consumer. So this could be a huge problem. This one.
Join the meeting.
This ballot initiative was numbered Proposition 15. So look out for it. And again, we got to vote no for this. Now, why does this matter, this Prop 15 or split roll matter to somebody who runs an apartment association? Well, we believe that this is only the camel peeking under the tent, and eventually somebody's going to come after apartment owners, and we can't let this pass. We need to protect Proposition 13. So again, no on 21, no on 15. I want everybody to go home and chanting it constantly, and tell your friends and family. You can go to the next slide. I want to talk to you about some laws that were passed and became effective this year. Assembly Bill 1482, which is the statewide rent control and tenant protections law. Basically, this limits rent increases for properties that are not covered by local rent control and are not newer than 15 years old. It limits the rent increases to the CPI, Consumer Price Index, plus 5%. Last year in the LA region, that increase was 8.3%. CPI was 3.3%. This year, because of COVID-19, our economy had crashed a little bit. So the CPI was only 0.7%, and the maximum increase now for the LA region is 5.7%. And again, this covers non-local rent controlled properties that are built after or built before 2005. So as an example, in the city of LA, they passed their rent control ordinance in 1978. So only properties built up until 1978 are covered by local LA rent control. For city of LA, properties covered under Assembly Bill 1482 would be built after 1978 up until 2005. There's a rolling 15-year exemption on new properties. So by next year, anything built 2006 and before would be covered by the state rent control law. There's a number of exemptions under this. Those include owner-occupied duplexes and single-family homes if they are not owned by a corporation or an LLC that has a corporate member. And again, anything built within the last 15 years would be exempted. This also provides for just cause eviction rules. And, you know, again, those are the typical non-payment of rent, breach of lease, or even an owner move-in is allowed. And then there is an allowed eviction for what's called a substantial remodel. A lot of people ask about that, so I like to mention that. And what a substantial remodel means under the law is that the work you're doing to in a unit will take more than 30 days. During those 30 days, there will be unsafe conditions in the unit such that the tenant cannot remain in the unit, and the owner has pulled permits to do the substantial remodel. If there's interest, I do have some extra slides in an exhibit to this presentation, and I could definitely do a deep dive into Assembly Bill 1482, but I'm happy to make my slides available to everybody who's attended today so you can read up on them yourself. There are some notice requirements, which I know are in the CAR forms. The notice requirements, there's 2 notices that are required. You either have to let renters know that Assembly Bill 1482 is applicable to them, or you need to let them know that your property is exempt from Assembly Bill 1482. And the deadline for the notices are July 1st for new leases. So these provisions need to be in new leases. And again, I know they're in the CAR form leases. They're also in our apartment associations leases. And then August 1st for existing leases, you need to provide a separate notice if it's not in your existing lease. We also have Senate Bill 222 and Senate Bill 329. These prohibit discrimination against voucher holders. And so anybody who may have a Section 8 voucher, you have to consider that Section 8 voucher as their normal income. You can't say, I don't want to participate in Section 8 housing, so I'm not going to accept your application. You have to give consideration to that. And we are hearing about some of our members getting these baiting calls, people calling up and saying, I'm a Section 8 holder. Do you work with Section 8? And owners just say, no, I've never worked with Section 8. I really don't want to work with Section 8. You can't say that anymore. You have to offer the person to put in an application, and you have to consider the Section 8 voucher as income, just like any type of salary or other income the person may receive. We also have Senate Bill 644, which limits security deposits to active personnel. You can't charge more than 1 month to active duty military personnel or 2 months for a furnished place. California law limits security deposits to 2 months for an unfurnished apartment and 3 months if furnished for non-active military personnel. There's also a new 90-day notice increase for increases over 10%. Because Assembly Bill 1482 limits rent increases to the CPI plus 5% and no more than 10% if CPI were to increase radically, this bill would only apply to non-Assembly Bill 1482 properties or properties that are not covered by local rent control. So these are properties that are built within the last 15 years, and those would require a 90-day notice again for increases over 10%. You can go to the next slide. I just like to mention this bill. It's kind of forgotten about usually, but this became effective in 2019, and it's Senate Bill 721. And this requires, we call it the balcony inspection bill, but it requires inspection of anything that's in what's called an elevated exterior element. And these inspections need to be completed by January 1st, 2025, either by a licensed contractor, structural engineer, building inspector with at least 5 years of experience. And this includes basically any wood structure on a building that is above 3 feet and extends outside of the 4 walls of a building. So it can include balconies and walkways, decks, and porches. And it does include outside stairways if they extend outside of the 4 walls of the building. So again, these need to be inspected. The local jurisdictions haven't really caught up with this new state law yet, and they don't really have procedures in place to verify these inspections are done. But if you do get them done, or if your clients get them done, just keep the inspection report in a drawer, because eventually some local building and safety official is going to come calling and ask you for proof that you've done these inspections. And again, they need to be completed by January 1st, 2025, and then every 7 years thereafter. You can go to the next slide. So let's talk about a little bit of the craziness of what's being considered this year up in Sacramento. And by the way, our state legislature is on hiatus right now until July 13th. So they're all getting a rest while they devise ways to screw up the real estate industry and housing here in California a bit more. But we have Assembly Bill 828, which not only provides for a temporary moratorium on foreclosures, but also prohibits evictions. And originally the bill was proposed to require a 25% haircut to be taken by property owners, while it allowed for 12 months for renters to repay back rent. That 25% has now been removed. It also severely restricted an owner's ability to evict tenants and basically put the onus on landlords to prove their financial hardship when evicting a tenant. And if an owner owned more than 10 or more properties, it was just presumed that the owner was not having a hardship and therefore could not evict a tenant for non-payment. This bill is just slowly moving through the legislature. I'm not sure where we're going to come out. Assembly Bill 2580 is a proposed rental registry. Cities like LA, Beverly Hills, Santa Monica all have rental registries forcing property owners to disclose lots of different confidential information about their finances, which could become available to the public. That is the reason our association is suing the city of Beverly Hills and the city of Los Angeles over their local rental registries. And that is now proceeding through the federal courts today. You can go to the next slide. Assembly Bill 3260. What this would do is this would require, if it's passed, would require the property owner to offer the tenant the ability to either pay a security deposit over 6 months or secure insurance to cover the risk of damage to a property. This is something that came out of the state of Ohio, and the bill's author feels that it's just way too expensive for a renter to afford to pay a first month's rent on top of a security deposit. So this bill's author thinks that some relief needs to be given to tenants when renting a new property. This is one obviously we are opposing. Senate Bill 1079. This comes out of what happened during the Great Recession when Blackstone came in and bought up a lot of single family homes and other rental properties. This would limit any one purchaser to purchase no more than 3 foreclosed properties. Senate Bill 1157 would require reporting of both on-time and late rental payments. The bill's author would like to help facilitate renters to build their credit histories through their rent payments and eventually be able to afford to buy property on their own. And then Senate Bill 1190 allows different ways, additional ways for tenants to get out of a lease if they're subject to any type of domestic violence. And what this would include is even if they're a victim of a crime that causes physical injury, whether it's on your property or off your property, a tenant could just give notice to a landlord to break a lease without any type of penalty. You can go to the next slide. Assembly Bill 1436 is another one of the terrible proposed bills. And again, it's a eviction protection for tenants that are negatively impacted due to COVID-19. And it would allow, it would keep that eviction ban in place for up to 90 days after the lifting of the state of emergency with an outside date of April 1st, 2021. And it would allow tenants to repay rent over 12 months. It was originally posed as 15 months, and through lobbying efforts, we've been able to shorten that. And we're also trying to get a number of other amendments in this poorly thought out bill. The worst thing about this is that if there's an unpaid rent debt to the owner, it would convert that unpaid rent to consumer debt. So the owner would not be able to seek remedies in eviction court for non-payment of deferred unpaid rent. They would have to pursue some type of civil court case, or if the past due rent is not that large, small claims court action, basically assuring that the owner will never be able to collect this money, or would have to hire some collection agency who would take 40 to 50% of whatever they're able to recover from the tenant. It's just really puts owners in a terrible position, particularly for owners that now have been suffering with 4 months of unpaid rent and looking forward to at least another 3 to 4 months of that. Assembly Bill 2272 is a statewide eviction defense fund to fund attorneys for tenants facing eviction. Assembly Bill 2470 is actually a bill that was proposed by the apartment industry. And what that would do is it would allow, just on a ministerial decision, not having to go through design review or a planning commission, allow for the splitting of multifamily dwelling units. So taking a duplex and converting it into fourplex as an example. And then Senate Bill 1015 would be a tenant assistance fund. There's no amount, however, specified for this. In general, our association supports tenant assistance funds, anything that helps tenants to pay their rent. We usually support, and we think that that kind of support should be coming from the government. They're the ones who created the situation that we're in by shutting down the economy, and they shouldn't be looking to private property owner citizens to help fund free housing for people. That's just my opinion. You can go to the next slide. The latest in egregious bills is Senate Bill 1410, which is an emergency assistance fund. What this would do is this would allow for renters to repay the deferred unpaid rent to the state of California over a 10-year period starting in 2024. Also during that 10-year period, owners would receive a tax credit equal to the unpaid rent. The bill is voluntary, apparently, but owners are required to offer this payment scheme to their renters, which means, you know, anybody in their right mind would rather pay their past due rent over 10 years starting in 2024 rather than some other shorter repayment scheme. So the fact that it's touted as voluntary is really illusory. But anyway, we are completely against this bill too, and pushing to have it defeated. So if you go to the next slide, I'm not sure how much time I've taken, but I'm happy to take questions. I know I covered a lot of material pretty quickly, and you know, like I said, I do have some availability to do a deep dive into Assembly Bill 1482 if anybody were to be interested, but I'm happy to provide my slides. So I'll just be quiet and wait for a question.
Daniel, we did have one question in the comments. Someone asked if landlords are receiving money for lost rents. I'm not sure if you specifically touched on that when you were speaking on that, but that was the only question we had submitted on chat.
Okay, that's a great question. So for the most part, no. However, by and large, you know, particularly on a national average, and it varies throughout our local region, owners are collecting rent. I think the national average is somewhere around 18% of tenants are not paying rent. Here locally, and you know, this is just information I received talking to some large property management firms. You know, in some cases, you know, there's a 90% payment rate. In other areas where there's large populations of hourly employees, or particularly in areas like in East Hollywood, where you have a lot of people impacted by the entertainment industry, the non-payment rate is much higher, and so only about 80% of rent is being collected. But there's literally no programs to help rental property owners today. There, because of the CARES Act, there has been some federal funding that is going into cities. And so now you're hearing about the County of Los Angeles with a tenant relief program where they're going to pay up to $1,000 or $1,200 per month for up to 3 months, pay directly to the landlord for tenants that qualify. And typically that qualification is for people that are about 80% of the average mean income. And the city of LA has recently proposed a fund as well. I think it's a $100 million fund where they're going to pay $1,000 or $1,200 a month directly to owners. But that's pretty much all the relief. There's been a lot of talk about loan forbearances and things like that. But when owners have called their banks, they've been told that to get a forbearance, and while the banks in a lot of cases are willing to entertain it, there will be higher interest rates, there will be fees associated with it, and people's credits are going to be dinged if they ask for a loan forbearance. So that isn't really the solution. There's been a lot of monetary relief that have been given to renters, particularly through unemployment income and federally subsidized unemployment income. And of course, the fact that there's an eviction moratorium and renters literally do not have to pay rent if they don't want to. That has been a major piece of relief for them, but there's really been nothing offered to rental property owners. And a lot of them that I speak to, and the majority of our members, about 74% own 5 or fewer units. So these are real passive investors in rental property, the mom and pops of the world. And many of them are retired and they depend upon this rental income to supplement their Social Security. And a lot of them are suffering. A lot of them are worried that they don't have emergency funds to last much longer and that they're going to lose their properties. And I hear these stories all the time. And so, you know, kicking the can from the renters onto the backs of property owners who are now expected to go to their banks for relief, that's just not going to cut it. We didn't even get property tax relief. You know, the governor came in, I think it was on May 16th, long after the April 10th deadline for our property tax, and said, okay, if you meet certain requirements, you can have property tax relief. Well, nobody, you know, if they had the money sitting around, nobody was going to wait to take a chance and not, you know, and get dinged with the 10% or 15% penalty on property taxes. It's just ridiculous. So there are a lot of people suffering. There seems to be a misconception out there that just because people own rental property, they haven't lost their full-time jobs or they're not at risk of coming down with COVID-19. Well, you know, I talk to a lot of people who are in those situations and not collecting rent at the same time. And it's just a sad situation because nobody is helping them out. And that's my soapbox speech. I apologize for that.
No, it was great. We have one other question that came in. Do you see any bills on the horizon or talks of any bills that might defer mortgage payments for landlords? Is there any discussion of actually helping the landlords out?
Yeah, and some of these bills that are being proposed, there are some mortgage relief, but you know, the state could talk about that all they want. The problem is they don't control the banks. It's the federal government that controls the banks. So what the federal government has done is if, you know, you have a federally backed mortgage, you know, a Fannie Mae or Freddie Mac, you can get some type of rent relief. But as I said, you know, these things aren't cheap all the time. They come with higher interest rates or fees, and your credit can be ruined. They're going to put something on your credit and you may not be able to refinance your property for many years to come because of that. It's probably not worth it.
That's all the questions that I had. I just wanted to mention that we will post the recording of this presentation and Daniel's PowerPoint on our website, possibly by the end of today. I mean, with our IT person, so that you guys can access it after the fact. And so that's all that I have. Daniel, if you had anything, any last comments or anything else like that?
Yeah, thank you for that. And thank you everybody for sitting here and listening to me. I hope I didn't put anybody to sleep, and I hope everyone has a great 4th of July holiday. I just want to mention one last thing. If you have clients investing in rental property, it is just really important, unless they're an attorney, unless they're a longtime real estate professional like you guys, it is impossible to be in this business today as a passive investor. And what they need to do is they need to at least join an apartment association. It could be ours. Ours has been around 103 years, or it could be any other one. But in order to know the information they need to know to operate successfully and avoid what could be substantial liability, and most importantly, to support our industry so we can fight back against all these awful attacks on our property rights, they need to be in an apartment association, need to support the apartment association. And it's also very important that they give to CAR's political action committee or our political action committee to fight Proposition 21. We cannot let this pass. Michael Weinstein, the president of the AIDS Healthcare Foundation, is backing this thing again. He's going to put up $20 to $30 million. That means we need to raise 3 times that to defeat this thing again. And we will do it, but everybody needs to help fund this opposition campaign. It would have devastating impacts on housing in California, which would hurt your jobs and hurt your careers. So don't let it happen. And please make sure you give generously when you receive that inquiry from the CAR PAC or from your local real estate association PAC. Make sure you give, and you give as much as you can this year, because we have to beat this rent control ballot initiative. And again, vote no on 21, vote no on 15. And thank you again for letting me talk to you today. And I'm happy to do it anytime. Take care, everybody.